I'm going to jump right into the subject matter today. And thank you so much for joining us. I'm John Miller. I founded Rock Solid Law and Title 31 years ago. We close real estate professionally on time. We represent entrepreneurial small business owners, and we protect families through estate planning. Today, we're in the estate planning area, and specifically, we're talking about funding of trusts. And I'm only disappointed in our own ineptitude in getting online because we had a whole lot of people signed up today, and maybe they'll join us in a moment. About half are on board, so thank you all for being here. So in talking about funding of a trust, I think I need to back up one or two steps. Why would someone have a trust? The first and most basic reason is so that a family can avoid probate. And candidly, I was on the phone not 10 minutes ago with a gentleman who sadly lost his son, who was in his 50s, too early, but he left, the son left behind a minor child and an adult child and no will. So they had to go through what's called intestate probate, which is candidly even worse than having a will to go through probate. But whether you have a will or don't have a will, you're going through probate, which means you're going to court. It's expensive, it's time consuming, and I say it's where families go to fight. I say that with pretty good cause because I've been doing this since the mid 80s and I've seen it over and over and over again. So among the many things a trust can do for a family, avoiding probate is first and foremost, and will save a lot of money, save a lot of heartache, save a lot of time. Additionally, a trust is the only way that you can determine distribution, or as some people call it, determine distribution after your death, or as some people call it, controlling your money from the grave, right? So you can write rules on how the money is going to be distributed. But the only money that's, or things, or property that are under the jurisdiction of your successor trustee, the person you've appointed to take charge of your affairs, are those things that you have properly titled into the trust. The trust can only govern that which it owns. Makes sense, right? By the way, I do tend to talk a little fast in these. Right about here is a question and answers box, and right about here is a chat box. If you need to ask something, let me know, and I will leave some time at the end to field some questions. So I want you to imagine a trust as being a vessel. I always say a basket, a bowl, a bucket, whatever works best for you, but it can be anything that can contain other things. And that vessel, that basket, that bucket, you are in charge of as trustee, assuming you appointed yourself, which everybody does, during your lifetime or during your capacity, literally. If you become unable to do it, you will have already appointed somebody to take care of your business for you, right? So during your lifetime, maybe it could be a backpack. You carry all the stuff that you've put in the trust in that backpack, in that bucket, in that basket during your lifetime, and it's yours. You can do with it what you want. There's absolutely no difference in your ability to manage those items than if you owned them outright, okay? No loss of control. That's very important to a lot of people. So what is trust funding, John? People ask me that all the time. Because funding, when you fund something, that means putting money into it, right? So trust funding is actually taking all the appropriate assets that you own individually or as a couple, personally, and retitling them into the trust, changing the title of those things into the trust. Real property, bank accounts, beneficiaries of life insurance policies, beneficiaries on retirement accounts, stock trading accounts, all sorts of different things people own. And folks, I'm always learning new things that people own. oh gosh, I had a good example recently, but it's not coming to me. But, you know, people will have, oh, I know what it was, a fabulous collection of very valuable clocks. I'm 35 years into this practice. I never had anybody that owned a valuable collection of clocks before. Do know people that own valuable collections of guitars. And so whatever it is that you have that has value needs to be owned by that trust. And the act of getting them to be owned by the trust is called funding. Now, each different item will have a different manner of getting funded. Bank accounts, you do through a form at your bank. Life insurance beneficiaries, a form at your life insurance policy. Real property, a deed. Everything has different things. And by the way, qualified retirement accounts, 401ks, IRAs, SEPs, all of those things, there's a whole different set of rules that apply to them. So this is not, I tell you, it's not rocket or brain science. Well, try that again, John. It's not rocket science or brain surgery, but there is a knowledge base that can make it go a whole lot easier than if you don't know what you're doing. And there's the key, right? We all know that people procrastinate on getting a will and or trust, right? It's one of the great procrastination things in people's lives. People say to me, we're doing a very adult thing now. We're finally getting this done. And I said, that's great. Let us help you through it. I love to do that. Now, why doesn't every law firm help with funding? Why doesn't that happen automatically with every trust that's ever created? Most law firms, and my own practice some years ago did this, give you a piece of paper with instructions that you should now go fund. Why is it important to fund? Because unless you transfer title into the trust owns nothing. And if you die, you're going to go right back through probate. Why do some otherwise fine law firms not help you with funding? Because when you go through probate, where do your children go for legal advice? That same law firm. And guess what? The probate costs more than setting up the trust in the first place, so they get paid again. And if their clients die during their practice lifetime, they get the money. But when they if the clients outlive them, when the lawyer goes to sell their firm or invite new partners to invest in their firm, that's an asset. I don't think that's legit, okay? I think our job as attorneys is to protect you, and the best way to protect you is to get those assets funded, retitled into the trust, okay? So now you know why I call this so important, because if you don't do the funding stage, if you don't do that step, all you've got is a pile of papers that don't do you or your heirs or your loved ones or the charity you wanted to leave money to any good at all, okay? So people call and they ask, what's the price of a something? And I go, well, you need to be able to compare apples to apples. So I really can't tell you the price, but I'll give you an hour of my time and let's talk about it. Now, is that hour free? If you don't hire me, it is. But of course, I put that, I contemplate that hour in the flat fee we charge to do trust and estate work. We also have our packages include funding. Why? The exact reason I just told you. It is the most important step. But when people finally get around to doing their trust, and then they don't do the funding step, it's worthless. And the procrastination to get the thing done in the first place, if we just say, now run along and do the funding yourself, here's your instruction manual. My experience as a 35 or whatever it is year lawyer has taught me that people don't do it. That's something they can procrastinate about too, right? And it goes in the bottom of the to-do list and it doesn't get done. Therefore, we include funding in every package. Hey, John, are there clients that you will do a package without funding? Yeah, I sure will. If I know absolutely for a fact that somebody is going to follow through themselves, there are certain people that are just very orderly and are going to be willing to do that, fine. But guess what? We're going to nag them until it's done, right? They go on a list of people we call regular and say, is it done? And you know what they say? No. And after about 6 months, they'll usually turn around and say, oh man, will you do this for us? And we'll go, of course. That was offered to you in the beginning, and we'll be glad to do it now. So funding, I guess it's a fancy term, but it just means moving the title of everything properly into your trust. Now, since I'm talking about funding, I want to mention the pour over will. Now, if you do a will-based package, a last will and testament is the distribution instrument. If you do a trust-based package, the trust is going to be the distribution instrument. But it will also have a will in the package. And that will's only job is to leave behind whatever you've forgotten to title in the trust and dump it into that basket, okay? Still got to go to probate. It's still expensive. Your heirs are still like, Dad, why didn't you do that? And I'll tell you, I love this story because it proves itself true over and over and over. After we do the work for folks, they'll walk down to their little bank and they will open a little account, and it'll be their vacation account, their Mad Money account, their shopping account, their gambling account, their Vegas account, their hobby account, and they open it up in their own name, and they forget all about us, all that we've talked about, being sure that everything's in the name of the trust. And the paradox is, when people pass, this account has between $6,500 and $10,000 in it. I don't know why. Happened again this summer. I see it over and over and over. It's kind of like mad money, right? People don't really think about it. It's there when they want it. It's the money they just let themselves spend on whatever that's outside of their budget. So in this case, that pour over will would scoop that account up and put it into the trust. Why is that important? Because inside the trust, you've written the rules of how people are going to inherit from you, right? If there's somebody that has an issue with addiction, you can require testing before they get distribution. You can also step out any number of years before distributions happen to protect people from losing everything in an early divorce, a bad divorce, from frittering away in their 20s, right? From blowing it on something. But you can decide how much you want them to have. You can designate health, education, welfare. A lot of people leave money for secondary education, that sort of thing. So the short of it is that funding is merely moving the title of everything that you own individually, taking this pile and moving it into the trust. Once it's in the trust, then you're still in charge of it during your life, and your successor trustee takes over when you're incapable of managing it. Okay? I cannot believe that I've been that much of a model of clarity, because I don't see a single question or anything in the chat bar. So this is your opportunity to throw any questions about funding of trust at me. I will say, while you're thinking about that, any of you that are on the chat today, if you would like to sit and talk about your personal situation with respect to a trust and funding a trust, I will give you that hour. You will not have to pay for the consultation. Just mention to my team when you call or email us at questions@rocksolidlaw.com that you attended this webinar, and I will be absolutely delighted to sit with you, answer any questions that are too personal to ask on here. I know that people don't ask questions on the webinar because we don't want to air our dirty laundry in public. Which, by the way, is another use of a trust, because trusts don't go to court. They're not public record. Nobody that you don't say gets to see the trust gets to see what you decided to do with what you have after you're gone and don't need it anymore. Okay? Well, I'm absolutely shocked there aren't any questions. I'm gonna tell you something. You probably noticed over the last 2 years or so, I'm not wearing ties anymore, but today I had to wear my Beatle tie because my wife and I are taking our children to see Ringo Starr tonight. And I understand he's going to play 6 or 7 Beatles songs. So that should be very exciting. Okay, I'm really happy because somebody's asked a question. Thank you so much. Is the process of funding a trust the same for an irrevocable and revocable trust? So in typical lawyer fashion, the answer is yes and no. We have to take into consideration the loss of control involved in the irrevocable trust. So typically when we have an irrevocable trust situation, we are either concerned with asset protection or perhaps tax benefits. So we're only going to fund certain assets into that trust. There are trusts like ILITs and SLATs that are typically set up predominantly for life insurance policies so they can grow tax-free. And so we would only fund that one item. So really, that's a fantastic question, and it's entirely driven by fact. The actual act of funding, the actual transfer of the instrument could be by exactly the same method, a deed or some sort of assignment, or coordinating with the financial planner or insurance agent to get that done into the trust. I would say that the process is the same or similar, but the process of analyzing the appropriate assets for the irrevocable trust as opposed to the revocable trust would be different. So fantastic question. You took me right to the next level. That's a great one. Love to discuss that one sometime if you like. Are there any other questions this morning? Oh man, I really appreciate you guys joining me this morning. I've had the opportunity, we've been invited to speak about estate planning at a church this morning. And I had the opportunity to say, I really do consider this law firm as our ministry, and that we love to contribute to the community. And these little educational systems are how we do so. Thank you for joining me. I'm not seeing any other questions. If you have questions you would like to share offline, not online, please do at questions, that's plural, questions at rocksolidlaw.com, and we'll get you an answer. I'm going to leave you with Ringo Starr from the album Peace and Love, singing to you about his former queen, Elizabeth. We'll be doing this again. Please join us then. We obviously had a lot of people sign up, and so there's interest in the trust area. I'll probably answer some more trust questions in the future webinars. If you guys have specific subjects you'd like for me to address in a webinar, please also feel free to shoot an email to that questions@rocksolidlaw, and I'll take it up next time. Thanks for joining us today, and as Ringo Starr would say, peace and love.